Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Well, a lot of you have been asking questions about the case of Sullivan v. Ferguson. What is Sullivan v. Ferguson? Well, that is the case filed in the Western District of Washington State to overturn RCW 9.41.370, better known as Senate Bill 5078, the standard magazine capacity ban. Now, as we know, there has been a lot of activity at the United States Supreme Court, especially in the Bruen opinion, which may have changed the complexion of that litigation. So, today, we're lucky enough to be joined by the head counsel for the petitioner, Sullivan, in the matter of Sullivan v. Ferguson. That's Joel Ard. He's going to join us in just a minute. So today, let's spend a few minutes talking about what's going on with the lawsuit to overturn Washington's magazine ban. Okay, so like I say, the issue we're talking about today is a pending lawsuit in the Western District of Washington State called Sullivan v. Ferguson. That is the lawsuit to overturn, to find that RCW 9.41.370, the magazine ban in Washington State, passed through Senate Bill 5078, is in fact unconstitutional. Lead counsel for that matter is a gentleman named Joel Ard. Now, he's brought in a big-hitting law firm from Washington, D.C. to help with this matter. But we are really, really proud to announce that we got Joel here to join us. He's going to sit down with us in a minute, and let's find out what is going on with Sullivan v. Ferguson. All right, everyone. Well, I am joined by Joel Ard, counsel for Sullivan in Sullivan v. Ferguson. Now, Joel, let me read you a quick little bio about you. This is pretty impressive. You litigate intellectual property disputes, including infringement, licensing, import, export, IP issues. You also litigate constitutional laws, civil rights, election and voting law cases, particularly focusing on issues arising under Washington state constitutional election laws. And Joel is a member of a very elite fraternity for the last 6 years, one that I've been fortunate enough to be a member of, which is you've been named as a super lawyer by both Washington Law and Politics and Seattle Met Magazine for the last 6 years. That's only one of 250 lawyers in the whole state. So, Joel, whatever you're doing it right. So congratulations.
Well, thanks very much. I appreciate that.
Yeah, welcome to the channel. We appreciate you being here. Tell us a little bit about how you first got involved in Sullivan v. Ferguson.
Well, I was lead counsel for NRA and Second Amendment Foundation in Mitchell v. Atkins, which was a challenge to the constitutionality of Initiative 1639, and not all of it, but a wide variety of the restrictions in that initiative, including bans on interstate sales, FFL to FFL sales to out-of-state purchasers, and then bans on purchases by under 21-year-olds of any semi-automatic rifle. That one has been pending at the Ninth Circuit for quite some time now. And while we're waiting for action on that, Second Amendment Foundation and Firearms Policy Committee asked me to, Firearms Policy Coalition, asked me to act as local counsel in Sullivan v. Ferguson. I'm really honored to be working with some fantastic litigators at Cooper and Kirk. Great team there, guys who've taken quite a number of cases very successfully to the U.S. Supreme Court, and it's really a pleasure to have the opportunity to work with them and learn from them on this case. Yeah,
Cooper and Kirk is a firm out of Washington, D.C., I understand.
That's correct.
And their resume, some of the cases that they've handled is pretty impressive.
Oh,
so
yeah.
There's some big guns here.
Superstars.
Sullivan, right?
Yeah, it's really a pleasure to be able to work with them and learn from them.
Why don't you tell the listeners right now, where does this case currently sit? What's going on with the case right now?
So it got filed shortly before, and I know we're going to reach this, the Bruen decision came down. And the expectation at that point was, depending on the timing and content of Bruen, that the Duncan case, which we're going to get to, would have an immediate effect on it. Then Bruen came down, changed the outlook, obviously, for us. The defendants at this point, everyone's been served, everyone's appeared, everyone's got counsel. Because of the location of the plaintiffs, we've obviously sued the state itself in the form of the Attorney General and state officials. Also, officials in King County who are responsible for enforcing the law against King County residents. And one of our plaintiff is a King County resident. Grace Harbor County officials responsible for enforcement in that county because we've got a Grace Harbor plaintiff, and then officials in Kitsap County. The Kitsap County officials moved to dismiss, saying, look, even if everything you say is true, it doesn't matter. We're not the right defendants here. You don't really have a claim against us. That motion has been fully briefed and is awaiting court action. Whether he asks for oral argument or not is up to the judge, but we'll see a decision on that in due course. And then the other thing going on in the background is an advocacy group has asked the court to allow them to intervene as a defendant and be an actual party to the case, a step that we think is not supported in Supreme Court and Ninth Circuit law and that we've opposed. So we're awaiting a decision on that as well.
Now, Sullivan is filed in the Western District of Washington. And when I was looking at Court Listener, and I'll put the link for my viewers down below so you guys can kind of follow this case as it goes through, it appears that a similar suit has now been filed in the Eastern District of Washington. Are you privy to any information on that?
No, we're obviously aware of the suit. It's, again, as you say, filed in the Eastern District. It's in front of Judge Mary Dimke, who's recently confirmed to the court out there. We, in turn, are in front of a recently confirmed judge in the Western District in Tacoma, Judge Estudillo. Both cases are in the very, very early stages. Both courts have been made aware of the pendency of the other case. You know, a judge, you don't want to have, you prefer, if you're a judge, not to have a decision that conflicts with your sister court in the other side of the state. So we've appropriately made both judges aware of the pendency of the other cases, and that's all we have right now. Whether there's some move to merge or consolidate them would be a decision down the road.
So that's a possibility, but that remains to be seen.
That's correct.
And the named defendants in Eastern Washington is probably the State Patrol and then some various jurisdictions located east of the mountains. Is that your...
That's my understanding, yeah.
Okay, okay. Now, you mentioned something earlier. So this suit gets filed before the holding comes down in New York Pistol and Rifle Association v. Bruin, a ruling that all of us were anxiously awaiting. And then the ruling comes down, and there is a very clear announcement by Justice Thomas as to what the analysis is that appellate courts shall use when reviewing gun control legislation moving forward. How has that changed the complexion of Sullivan v. Ferguson since the holdings of Bruin were announced?
So the most important, quickest change is not merely the holding in Bruin, but something else the Supreme Court did shortly after that. While awaiting Bruin, there had been a number of cases from various circuits that had petitions for cert filed that were just pending at the court. They hadn't taken them up. They hadn't rejected them. They're just kind of...
They were just on the waiting list. And
on the waiting list,
exactly. One of them was Duncan v. Bonta, which is a Ninth Circuit case that deals with California's magazine ban.
Right. So, you know, practically indistinguishable statutes, a ban on those standard capacity magazines in California. Washington has the law that we're challenging, you know, virtually the same kind of ban. In Duncan v. Bonta, the trial court had struck down the ban with an analysis that, you know, to my mind, is a little prescient of what Justice Thomas said in Bruin in the way he approached analyzing whether or not the Second Amendment protected, you know, purchasing, owning, transferring magazines with a capacity of 10 rounds or greater. The Ninth Circuit reversed that and said, you've done it all wrong, and went through that two-step analysis. Well, Bruin says 2 steps is 1 step too many.
That's right.
And then they went to this holding pool of all sorts of cases that were awaiting a decision by the Supreme Court. Will you or will you not take this case up? And they did what's called GBR them. Grant the cert petition, vacate the decision of the court below, and remand it. And basically what they're saying is, we're not analyzing this law. What we're telling you is you need to analyze it the way we did in Bruin. So the Supreme Court hasn't exactly spoken to a ban on 10-round magazines, but what they did say was, hey, Ninth Circuit, the way you looked at a ban on 10-round magazines is wrong. we're vacating your decision. It's like it never happened. We're sending it back down, and we're giving you an instruction to read Bruin and analyze a 10-round magazine ban like we analyze the law at issue in Bruin. And they did that with a number of other cases as well. So circuits around the country have now had various firearms restrictions handed back to them with an instruction: do it over. You need to analyze this again, but this time do it the way we told you in Bruin.
And for our viewers out there, there were 4 cases. There was one called Young v. Hawaii, which dealt with Hawaii's crazy concealed carry laws. Then there was the Duncan v. Bonta, which we talked about. But then there's also New Jersey Pistol and Rifle Association v. Bruck, which is New Jersey's magazine ban. So that case got GVR down. And then I believe the last one was a case called Bianchi v. Frosch, which deals with Maryland's assault weapons ban, right?
Yep.
Okay. Now, I don't do appellate work. You do a lot of appellate work. What is when a court GVRs, grants, vacates, and remands, are they telegraphing anything to the lower court other than, hey, this is a do-over, apply the law correctly this time?
In a situation like this, where you have a major lead case that is, long awaited, years in the making, everybody, including many members of the Supreme Court, in a lot of, denials from search grants and so on and so forth, have been saying, hey, people aren't paying attention to Heller. We need to give the lower courts direction. This isn't working. So Bruin comes out. It's a big deal.
Huge.
It's a big deal in a lot of ways, not just for the Second Amendment, but it's signaling to a certain extent a new approach or a slightly different approach to constitutional analysis with the text, history, and tradition instruction.
Right.
So for a variety of reasons, the court's not going to take 2 different magazine bans, an assault weapons ban. They did one carry case. They've got another one coming from Hawaii. One thing they do look for is that lower courts take their guidance in a case like Bruin and apply it to these different circumstances so that they're not the ones doing all the work. Does that mean they necessarily conclude, hey, the assault weapons ban is definitely constitutional and we're sending this back to you so that you can, rubber stamp an opinion like that? No, what they're sending it back to do really and truly is apply Bruin. Look at the text, history, and tradition of rights to keep and bear arms as they were understood at the time of the adoption of the Second Amendment, and analyze this particular restriction within that text, history, and tradition the way we said to do it in Bruin.
And obviously, that's the end of the analysis at that point. We don't go to that second step and start balancing society's interest versus the infringement upon the individual's rights. And that's what's really allowed a lot of these circuit courts to kind of put their thumb on the scale one way and ensure that many of these very restrictive gun control legislations remain constitutional. Agreed?
Yeah, I mean, you see that in the original Heller decision. The dissent says, hey, we should have a balancing test. And Justice Scalia says there was a balance struck, and that was adopting the Second Amendment. Someone else did that for us. It's not our job anymore. As judges, as justices, we don't do the balancing test because the drafters of the Constitution and the Second Amendment did the balancing test for us. And we are not supposed to be inserting ourselves and our policy preferences back into that mix through this means of a balancing test. Obviously, every circuit court took up a 2-step process of, is it protected by the second, is this conduct restriction, whatever, protected by the Second Amendment at all? If there's no Second Amendment protection, the people can do, the legislatures can do whatever they want. If there is a Second Amendment protection, then they would go down the road towards this balancing test. And ever since Heller, you saw increasingly other justices on the court saying, whether in dissents from denial of cert or in other circumstances, hey, this is going off the rails. That's not what we said in Heller, and we need to step in, because at this point, virtually every, trying to think if there were any at all, restrictions that a court of appeals would find enough of a balance in the public interest to say, well, sure, that might be protected by the Second Amendment, but the public interest allows that restriction.
And interestingly, it was Justice Thomas who was, in fact, one of the most vocal ones in a lot of these dissenting opinions when they were denying. He was consistently complaining, like, what are we doing here? And so it turned about as fair play. It's kind of, serendipity that it comes around that he gets to author the Bruen opinion then.
Right. And so now we're going to see a number of cases where courts are going to have to analyze, is this type of weapon, is this type of magazine, is this type of conduct and activity the type of thing that fell within the text, history, and tradition of the right to keep and bear arms as it was understood when the Second Amendment was adopted. Obviously, we see in a GVR of Duncan, that means for Sullivan specifically, if that case was on the books, Judge Estudillo would look at it and say, the Ninth Circuit has already spoken to this issue, right? In Duncan, they said there's no Second Amendment protections that limit the state's ability to ban 10-round magazines. As a lower court judge, I'm bound by that. So that was just the state of play when the case was filed.
Right.
Now that Duncan has actually been vacated, that's not good law. He's not bound by Duncan v. Bonta. In fact, it's as though that decision were never written. So he has a blank sheet of paper to write on, but not entirely blank, because lo and behold, the district court in California, who wrote the original opinion in Duncan, the trial court opinion, did a great analysis of text, history, and tradition. And again, I think it's almost sort of prescient, like, hey, what's Justice Thomas going to say is the right way to analyze these restrictions? So it's a great opinion. We think it's probably where the Ninth Circuit is going to come back down, that they're going to say that's actually the analysis that the Supreme Court has instructed. And we certainly are confident that they're going to find that magazines of higher capacities than 9 rounds were, in long-standing common use for a long time before the Second Amendment was adopted. No restrictions of that sort are found in historical laws, so that text, history, and tradition test, I think we're confident the courts are going to say, yeah, under the text, history, and tradition test, the state is not allowed to limit those magazine capacities, because the ability to own larger capacity magazines of whatever style they were back in the day was well accepted as within the rights protected by the Second Amendment.
And let us also remember that Duncan won at the trial court level. I think it was Judge Benitez there in San Diego. But then Duncan won in front of a 3-judge panel in front of the Ninth Circuit. And then they impaneled the full Ninth Circuit. We kind of knew the fix was in at that point when you get in the whole Ninth Circuit together. And that then and only then did it get flipped. And that's the ruling that's been vacated now by the Supreme Court.
Yes, but it does go back because the panel ruling vacated, the en banc panel vacated the 3-judge panel.
Okay.
So it's not as though vacating the en banc decision restores the 3-judge panel ruling. The 3-judge panel is going to get that back.
Okay. Interesting. Now, let me just ask you this, and I'm going to have you look into your legal crystal ball for a second here.
Sure.
And if we were this good at predicting everything, you and I both can quit practicing law, move to Vegas, and retire in a week. Okay. But
that's right.
If the Ninth Circuit properly applies the law as clearly announced by Justice Thomas in Bruen, is there any way that California's magazine ban should stand a constitutional test?
No, I think both California's and Washington's. I think if you look at Judge Benita's excellent trial court opinion and the opinion of the 3-judge panel, it's almost like they're predicting what Justice Thomas was going to say, which isn't too hard, because a lot of it came right out of Heller, that we're not supposed to be balancing, that these balancing tests are a way of judges inserting their policy preferences into an area where the Second Amendment has taken the policy preferences away from the courts and away from the legislature.
Because that balancing test allows for the injection of politics into the court's analysis. And that's a dangerous proposition, regardless of what side of the fence you're coming from.
Right. So I think we're going to see a 3-judge panel in Duncan. I would expect write an opinion very similar to what they did in the first place, because again, the analysis is somewhat changed. Bruin is a long opinion. It's very detailed. It gives a lot of guidance to appeals court and trial court judges about how to approach these things. And I'm sure that the panel that will sort of revisit Duncan, they're not just going to pull out their old opinion and dust it off and sign it again. They're going to take a very careful read of Bruin. I know any of your viewers who have read it, that's not a quick run.
No, it's a thorough opinion.
That's a good thick tome, and there's a lot to digest in there. And I'm sure the Ninth Circuit panel that's looking at this is going to take a considerable amount of time and give that a very careful and close read and revisit their decision in Duncan to ensure that they are following Bruin. The decision was vacated. You don't just pull it out and say, we think we got it right. You follow Bruin, you do that analysis again. I think at the end of that analysis, they're going to say these magazines are in fact protected under the Second Amendment, just like the firearms that they fit into. And with that, I think we'll have the same outcome in Sullivan.
So if the Ninth Circuit rules that in fact magazine bans are unconstitutional, that essentially would resolve Sullivan v. Ferguson and the companion case over in the Eastern District of Washington. That would be the law of the land at that point, would it not?
Well, it would certainly be the law in the Ninth Circuit, and we are part of that. So right. I don't see, it's hard for me right now to see the distinction that a court would draw if California's 10-round magazine ban is unconstitutional. I struggle to see a distinction with Washington's where you could say, oh yes, but this one is. So that's certainly my view.
Okay. Timelines. When do you anticipate that we might actually have some sort of resolution either on Sullivan or on Duncan v. Bonta?
Let's go gamble on the ponies, should we?
yeah, exactly. Throw rocks at the moon too, because we got equal chance.
So it's no secret that the Western District was a judicial emergency for years. Huge backlog in cases. We've got some new judges confirmed. They're moving things as fast as they can, but it's a slow-moving court right now. It has been for a couple of years. Like I said, we've got a decision that we need to get on a motion to dismiss a group of defendants, bringing in a defendant intervener. Those were just finished up and briefed to the court on Friday. It's going to be a few weeks at least before those are decided. I don't think there's any, at least not yet, anything similar in the Eastern District, and they might be moving a little faster, so that case might move ahead of ours. I would think, I wouldn't be surprised if either judge sort of waits on a decision in Duncan v. Bonta. I mean, that's going to be ultimately that case is ahead out of the starting gate earlier. It's ahead of this one. It's already at the Ninth Circuit.
More age on it.
And a trial court judge knows that there's going to be a decision in Duncan coming down relatively soon, and it probably in about the same amount of time that a trial court judge needs to analyze Bruin and write a thoughtful opinion on Washington's law. A 3-judge panel at the Ninth Circuit could do the same. Are they going to wait for that? They might. Are there things we might do to push it faster than that? We might. But for viewers excited about the outcome of Bruin, the wheels of justice grind slowly.
They do. They do. We move at a glacial pace.
We're not going to do anything hasty and untoward, and we will get good, thoughtful, well-reasoned decisions out of these courts in due course. But that's
any chance we could have some resolution before the end of this calendar year?
I believe so.
Okay, great.
Although, wow, the year flies by. It's August already, isn't it?
Especially when you're having so much fun like we have been having this.
That's right. I hope we would see decisions in at least, I think we'll see some movement on some front, whether in one of the 2 challenges within Washington State or Duncan or all of them. I would expect something before the end of the year that brings some clarity to this area in the Ninth Circuit.
Well, Joel, I can't thank you enough for your time. And I certainly, on behalf of all of our viewers, we cannot thank you enough for fighting for the rights of all the lawful and responsible gun owners in Washington State. I hope you'll be willing to come back and talk to us again, hopefully for a little victory celebration. But best of luck to you, my friend, to both you and your entire family, okay?
Well, thank you. And I want to make sure that I plug Second Amendment Foundation and Firearms Policy Coalition.
Yes.
Great organizations doing fantastic work. We're really pleased to be able to represent them and have their support along with our other plaintiffs. And any of your viewers who are looking to support the defense of Second Amendment rights, those are groups that are well worth supporting.
I agree completely. Alan Gottlieb right here in Bellevue with the Second Amendment Foundation. And I will put the links for both of those very worthwhile organizations in the description box below. And I do encourage our viewers to help kick in any way you can help these folks out. So Joel, once again, thanks a million for your time. We appreciate it. You stay safe, okay?
Great to talk with you. Bye-bye.
Well, hey, once again, I want to really thank Mr. Ard for taking time out of his busy schedule to join us. And like he said, and like I said, if you're interested in helping out either the Firearms Policy Coalition or the Second Amendment Foundation, the links for them are down below. We do encourage all of you to support these very worthwhile organizations. Listen, you may have more questions about Sullivan v. Ferguson or anything else related to your Second Amendment rights. And if you do, remember, you can always contact us at WashingtonGunLaw.com, or you can call us directly at 425-765-0487. Now, everyone remember, part of being the lawful and responsible gun owner, like we preach all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.